Chief Justice Warren Burger once wrote, "The obligation of our profession is to serve as healers of human conflict." Welcome to Lawyers as Healers, a podcast exploring an evolution happening inside the American legal profession. I am your host, Dave Albrechta. I am a coach, a mediator, and a recovering litigator. In this podcast, I'll explore how and why an increasing number of lawyers are moving beyond adversarial thinking to return to the obligation of our profession, which is to serve as healers of human conflict. All right. Welcome to Lawyers as Healers. Today, I'm really excited to be joined by Catherine Connor. Catherine's a mediator. She's been a collaborative attorney and a teacher at the Center for Understanding and Conflict, where she's spent decades helping people approach conflict in a different way than our traditional adversarial model lends us. And her work focuses on what's known as the understanding-based model of conflict resolution. And that's an approach that emphasizes curiosity and listening and understanding and empathy and helping people truly understand each other before getting to solutions and resolutions. And Catherine's been involved in this work for, I think, almost 40 years, over 40 years.
Yeah. Over 40.
And yeah, and has taught and practiced these ideas with lawyers, mediators, and families navigating difficult conflicts. So, Catherine, thank you so much for joining me. I'm really excited to have the conversation.
Thanks for inviting me, Dave. I'm looking forward to our
Yeah.
conversation too.
Yeah. So, to start, I'd love to hear kind of how you encountered the understanding-based model and how your involvement in the center began.
Well, a friend of mine told me about a training at the center when I had been practicing just about 3 or 4 years in the mid 80s. And so I went and took the basic mediation training, and it really spoke to me. I started trying to incorporate that into my practice. I had a small two-person practice at the time. It expanded a little bit. And I'd been doing primarily family law. So I started trying to do some mediation and also incorporate some of the ideas into negotiations and trying to settle cases before they would go to court. I was still litigating at that point, so I would do hearings, a few trials. And so that went on for about probably 20 years or so, maybe a little bit less than that. And then collaborative practice came along in the late 90s. So I was one of the initial people practicing collaborative law. And then I'd been doing some mediation all along and also taking advanced mediation courses from the center. And then I decided in 2000 to stop taking any more litigation cases. So it took me about 3 years to wind down my cases, including this last one. Both my client and the other attorney were terrible procrastinators. I'm like, "Can't we just get this done?" They're like, "Yeah, whenever." So I was really happy when I got that done. And then in 2004, a study group that I had around collaborative practice decided to ask Gary Friedman and Jack Himmelstein, the founders of the understanding-based model, to meet with us for a day and just try and help us talk through collaborative practice, how to incorporate the center's concepts, and to be working in a different way in collaborative practice. Also, because it was still relatively young then. So at the end of the day, Gary and Jack said, "One of you should be teaching this stuff." I'm like, yeah. And then we'd invited them to come to a big kickoff dinner we were having in our community about trying to bring collaborative practice awareness to the professionals in the community. And so I had been kind of the leading person on that. So I gave the welcome speech and talked about it. And then at the end of it, Jack comes up and goes, like, "You should really be teaching this." I don't know. I'm kind of an introvert. I don't really like to be in front of a lot of people, even though I am right now, but don't really like it. He goes, no, you should really do that. So, and then Jack went back to New York. So then Gary and I started doing collaborative trainings together, trying to bring the understanding-based model into that world. And then we've just been teaching together since then. I started teaching the basic mediation trainings, and then we've been expanding the concept into other areas, even besides in the legal. We've been working and expanding into the workplace. At one point, we worked with journalists about how to use the concepts when they're interviewing their sources. So just trying to spread it as wide as possible.
Yeah. That's amazing. You've been it's amazing that you've been doing it for this long. I think some people think that this stuff's all very new.
Mhm.
When lawyers learn about these types of mediation practices, I was that way. I was like, "Oh, this is like brand new stuff." But it's
It's been
been out
around
there for
quite
a
a
while.
while. Yeah. As
Yeah.
have I been around for quite a while.
I didn't mean to imply that. um, yeah, I'm curious, maybe before we dive deeper into the understanding based model, for anybody who doesn't know kind of these basic words that are listening, or these words as they're applied in kind of the legal field, that you could maybe just give us an explanation of the difference between collaborative practice and mediation and how those two are differ.
So I like to think of them as cousins because mediation has a neutral mediator working, could be with just parties alone. In some cases, that's what happens, or could be with parties and their lawyers in the room, or parties with consulting lawyers. Um, but if it doesn't resolve, the lawyers typically then go on to take the matter into some kind of third party adjudication. Typically a court, but might be some kind of private judging. Um, Collaborative practice is where there's a team of professionals that work with parties. So it could be two collaborative lawyers and parties, often a mental health professional working as could be neutral, they're often called coaches, or could be one for each party to help deal with the emotional aspects and help with communication, and then a neutral financial specialist who helps gather all the financial information, make sure the parties understand it. And then sometimes other professionals, if there's children, who might be a child specialist, who's the voice of the child, could be a vocational person, a business appraiser. So, kind of creating a team of professionals that helps the parties with the conflict. It's mostly used in divorces, but also in some other areas. So, a lot of overlap in terms of um, the goal, the use of professionals. In the collaborative practice, if the case is not resolved, the collaborative professionals all step away from the case. So the lawyers do not go to court with the parties. So that changes the dynamic and motivation to try and resolve it.
Yeah. Yeah, I love that collaborative model. At least in Colorado, it's very you can only do it in family law,
Mm.
and we're not really even permitted to do it outside of that. But I wish I wish it would be great in workplace settings. I was always jealous that we couldn't do that. Um, so I'm curious. You said earlier that I think you said that when you took the first class, the understanding based model just really spoke to you, and I'm curious what about it, spoke to you, or what you really connected with when you first found it.
Um, I think it's a couple things. One is that there is the motivation and kind of, you might say, drive of both the professionals. So if it's a mediator, that professional, but it could be others in that within that model. But the professionals to try and help people work through the conflict without exacerbating it, with really trying to get to the depth of what's going on rather than it being more of a positional bargaining process, um, which is what's often used in the legal world to try and resolve cases, which is here's my position, here's yours, this is what the law says, let's kind of work towards the center, or, it's much more um, on the surface at the top level and not what's underneath. And for me, and particularly as time went on in practicing family law, it was clear to me that there's so much going on underneath those positions that is one critical to helping people reach a good solution, but also has such an impact on the rest of their lives. Particularly if they have children, but even without children, the what's underneath that, the emotions, the complexity of it can have such a impact that using a model where people are trying to understand each other and what's underneath the realities, um, that's what spoke to me, that that's a better way of helping people through conflict.
Yeah. Yeah. And, I mean, it sounds like you discovered this fairly, or shortly after law school and kind of becoming a lawyer. I'm just wondering, like, what your experience was, learning about this approach and how it differed from your training, your formal training in law school, and just what that experience was like for you.
Well, the formal training in law school was learn about a case, how to analyze it, how to apply it to situation. And I went to law school. I graduated in '82, so a long time ago, and things have progressed since then. But there was very little discussion about how emotions impacted the dynamics between people, often the things that really drive the conflict, you just don't learn about in law school. It's at least the law school I went to. So that was something that I had to learn outside of law school through a lot of training and education. It was really great working in the collaborative teams because I learned a lot from the mental health professionals and the financial professionals. What I learned in law school was, yes, I learned about the law, how to apply it, and some of the principles and how to understand the principles under the law, which actually is still really a helpful thing to know. Uh, but there wasn't a lot of education around how to actually help people work through and negotiate a solution.
Yeah. Well, I will say I graduated in 2014 and had the exact same experience. So it's
That's
nice.
kind of sad, isn't it?
I know. I keep saying that too. I've said that a couple of times where I'm like, that was my experience, and I hope that things are changing and evolving. But I'm not sure that that's happening as quickly as some of us hope. um, yeah. So maybe you can tell, and I'll just note I've been through the Center for Understanding and Conflicts basic mediation training with Catherine, and a couple other teachers, and um, but a lot of people don't aren't familiar with the understanding based model. So I'm curious if you could just give the overview of how does what sets it apart? Why how is it different from mediation that a lot of us are used to in kind of the traditional setting?
So, even in sort of a traditional mediation, there's often an emphasis on, again, how do you apply the law to the case, or more on the surface. There's a lot of pressure involved. So you might, like, if you don't get this solved, you know what's going to happen. You're going to end up in court. And, depending on the mediator's style, it might even be going back and forth from room to room and telling one side, hey, I'm going to put a lot of pressure. And, this is the worst thing that's going to happen. You go to court. Then you go back to the other. This is the worst thing that's going to happen to you. So much more of a sort of pressure oriented, um, possibly even rise in level of real coercion to try and get people to reach an agreement. Um, and that often, can solve it and people may be satisfied, but often it leaves people feeling like a sort of a bitter taste that they had to give in because they didn't have a better option. In the understanding based model, instead, we focus on trying to understand, first of all, each person's perspective. Um, and sometimes it's almost not even clear about their own perspective. So it might be helping them to clarify really what is this conflict about? What's important to them? What do we need to take into consideration for the final solution? Is there something that's really core for them, their identity or meaning that's been evoked by this that we need to be thinking about and bringing it to the big picture? So we help each person understand that for themselves. And then hopefully they're also, while doing that, because we're in the same room together, they're hearing about the other person. So they're understanding better the other person's perspective on the situation. And what's often like the case is they really don't have a clear picture of the other person's perspective. They know what their position is. This is what I want, but not what underlies that, what brought them to that position. And that can really shift. the what people are willing to do or interested in doing when they have a bigger picture. And then we also look at, what are the realities of the situation, which also happens in sort of traditional mediation negotiation. Is there's a outside reality that you need to deal with. Uh, and just as in other mediation and the understand-based model, we brainstorm for lots of options that might not be available by going to court. But we want to kind of have this universe of possibilities. And then the step that we do that doesn't always happen in other mediation is we compare that universe of possibilities to what people have said is really important to them. That their needs, the meaning for them in their life, their identity, the things that are really going to drive them to say yes or no to a solution. We want to compare those and try and come up with a final solution that takes into account those needs, interest, what's important, meaning for each of them, so they can both feel they're able to say yes with sort of more enthusiasm, not necessarily always enthusiastic because they're in a conflict, but at least with a more sense of this is something that will actually work in my life and not like I just have to give into it.
Yeah, I'm glad you brought that up. Uh, prior to my discovery of these types of approaches and spending 10 years in the traditional systems, um, I heard so many mediators say to my client, um, the sign of a successful mediation is when both parties are unhappy and leave
I
unhappy.
hate that
I
phrase.
know, I know. And I've heard it so often in those settings, and speaks directly to that coercion approach. And they were oftentimes former judges, and it was this real kind of heavy-handed approach. Um, yeah, so maybe you can just speak to that. I'd love to hear your response, which we've already gotten a clip of. But what bothers you so much about
Well,
that
I think that's
that
such a low
approach?
bar, right?
Yeah,
That
yeah,
both
yeah,
people are unhappy. I mean, is that all we can hope for? Could we hope for something that people might say, this is the best that we could do under the circumstances? Yeah, it isn't exactly what I was hoping for, but it's really pretty good. I mean, that's a much better measure of that we really worked through it and came up with something that is the best possible option. So I think that's a much better way to look at it.
yeah.
Yeah.
I couldn't agree more. I there's this theme that keeps coming up as I explore these topics of lawyers. I think we all think of ourselves as good problem solvers. Like that's
Mhm.
a core kind of skill
Uh-huh.
that you need for the job. But we often sell ourselves short on when it actually comes time to solve a problem. Phrases like that come up,
Uh-huh.
and you're like, well, wait, hang on a second, aren't we problem solvers? Can we figure this out and like you say, hope for a more optimistic outcome?
Yeah, and I mean, I've done a lot of mediations where lawyers are in the room, and that is actually a great skill for them to have.
Hmm.
When we're at the point of problem solving, if they can be focused on that and not be
Yeah,
sort of into their litigation mode where all they want to do is kind of talk about how the other person's case is so weak. But if they can move into the problem solving mode, that's such a great resource for the parties. And sometimes, the lawyer for party A comes up with an idea that actually is a great solution for party B as well as their own. So, if,
yeah,
if have that be the main focus rather than sort of you know, the backup mode. That
yeah,
would be great.
yeah, yeah. I wonder. So I've been sharing some of these ideas on LinkedIn and other places, and a very common response, which I had this response to when I first learned about these models from lawyers, is this is too risky. There's too much risk to put the parties together in a room and let them talk, which now to me feels absurd. But in a space and time before I learned about these things, I was very much in that camp. And so I wonder just kind of what your I assume you've encountered that when you're working with lawyers and doing pre-mediation work, but what do you say to people who are worried about the risks involved in this kind of an approach?
I mean, I think that is a legitimate consideration for lawyers. Is my client going to say something that if it doesn't get resolved and we go to court will somehow harm them? And that is what lawyers are paid to do, is to protect their clients. So, I don't have a problem with lawyers thinking about that and thinking about the risks. The thing I think lawyers don't pay as much attention to is what is the risk of not being in the room, not talking, not disclosing information that would lead to a solution. And the risk there is they will end up in court. Their client will have spent a lot more money and emotional energy, and they may still not get what they want. Now, they might get what they want, but there is a risk that they wouldn't. And even if they got what they want when they went to court, the client could still be dissatisfied because they spent so much time and energy and money getting there. So that's the risk that lawyers also need to balance and help their clients understand and balance, because really it should be the client's decision about what they're going to be doing, whether they want to go forward with the mediation where there might be a disclosure of information that might harm them, or they might say something that would cause a risk to their legal position. And at the same time, what they say could actually be the path to reaching an agreement where the client would actually get more of what they want.
Mm, I love that reframe. It's so good. Yeah. Um, yeah, so, um, you've been at this a while, as we were talking about earlier, and I'm wondering if you're sensing a shift over that time and your time in legal practice towards these types of models. If you're just kind of what your finger on the pulse is of of the overall profession.
When I first started doing mediation, it was more where there were lawyers involved. And if there were parties, what I'm going to say doesn't apply. But when there were lawyers involved, what would happen is they would often come in right at the end of the case, where it's like last ditch effort before we're about to go to trial. And okay, we'll come in for a day, see if we can solve it. If not, we're off to court. Um, and over time, what I saw is lawyers starting to see the value of earlier work with a neutral. So it might be sort of in the case management realm, where as a mediator, I would help people from the beginning. Okay, let's have a plan. What information do people really need? Not what's all
Yeah,
the
yeah,
discovery
yeah.
you could do if you want to do your standard, 100 question interrogatories, but what is the information you really need to be in the position to reach a settlement? Let's figure out the most efficient way to do that, and let's then have this conversation. So it's like this progression to earlier efforts to try and resolve it. I think there's still a fairly strong, and I don't see it changing rapidly, um, use of the more shuttle mediation in the civil arena. In the family law, I think it's at least in my area, and it's different, obviously, in different locations. Because family law developed with mediators often working with the parties without lawyers in the room, but then when the lawyers join, it was often in the room, not outside the room. I think it's kind of a different path than civil cases. But in civil area, I think there's still more of the let's not have everybody in the same room. That's too risky. That's too dangerous. And more sort of the pressure oriented style of mediation.
Mm, yeah, yeah, yeah,
And I think there's
um,
two reasons for that. One is this
yeah.
whole idea you talked about of the risk and
Hmm.
lawyers being risk averse and not wanting their clients to somehow have a problem. And I think it's also that being in the same room is a more emotional experience because at least a lot of people, if not almost all people who are in a conflict, there's an emotional aspect to it. And that can come up more strongly when they're together in the same room. And I think as lawyers, we're not really prepared to be in that kind of situation where people are very emotional. We don't know how to work with it. We don't know how to help people when they're feeling emotional. And so I think that's part of the reason why there's still this hesitancy to be all in the same room because it can feel less manageable.
Yeah. Um, yeah, I can relate to that. And I think there's something there that I mean, lawyers really like control and
Mhm.
having control of
Yeah.
situations. And it's, you're kind of you have to inherently let some of that go when you get the two people together.
You just touched on one of my other phrases that I can hate so much, which is
Client
client
control.
control. Oh my, I just cringe when I hear that.
Yeah. So, well, say some more about that. I'd love to hear your take on that.
Because that's implying, just in the words themselves, that the lawyer should be controlling the client, and the lawyer is is the agent of the client, but they should not be the one controlling things. It's the client who's gonna make the final decision. It's the client that should be making the decisions. It's their life. And the lawyer should be an advisor to them, should be there to protect them, but not to control them. I just actually find that kind of offensive that they would think they should be controlling their client. They should be advising, educating, protecting their client, but not necessarily controlling them.
Yeah. Yeah, and it's interesting because I feel like when I think back, on my litigation experience, I'd often hear it or use that phrase to explain others. So I would always say like, that lawyer's having client control issues.
Uh huh. Right.
That's- I would use it to project onto other people, not,
Uh-huh.
um, yeah, it's fascinating. So I wonder after doing this work, what continues to inspire you about um, this type of mediation and the work you're doing with the Center for Understanding Conflict.
Yeah. I think what inspires me is that if we could help people to figure out how to navigate conflict in a way that creates better, more satisfying outcomes, whether it's settled or not, because even sometimes something doesn't get all the way resolved, but they have made some kind of progress in a way that's felt better because it's taking care of things that might be, for example, non economic, the emotional side, acknowledgement of something that's happened, sometimes an apology. Um, that if we could help people to learn to navigate conflict differently, um, that would be a service to the people we serve, probably their families, because maybe they'll take a little bit of what they learn to their families, to their communities, to the world, which could definitely use it. So that's what inspires me, is to keep trying to help people learn to do it differently.
Yeah, I love that. Um, so I'm curious. I have two kind of final questions before we move towards wrapping up. Kind of on that in that line of thinking, I wonder what kind of quick bit of advice you would give to people, lawyers or non-lawyers, who are experiencing conflict in their lives. What's one thing or one approach that they could shift or do differently to help improve, how they're showing up to conflict?
I think the most critical skill and capacity is the ability to listen very deeply to people. We have a tool that we call, or a process called the loop of understanding. And the first step is to really be fully present and ready to listen to someone, to be open to what they have to say, curious. Um, and that's really hard if you're one of the parties to conflict. If you're a professional, it could be a little easier because you don't have quite the same emotional reaction. But to just be there ready to listen. And I think that's so critical because I think lawyers, other professionals, people in the workplace, when you come into a conversation where there's conflict, you have a lot going on inside of your head and inside of your body and your emotions that may have some judgment, some blame, distracted ideas, and something totally unrelated to the conflict. And you're actually not fully there and ready to listen.
Yeah.
And I think if you're in that place, then you can listen quite differently and take in what someone else is saying and really digest it yourself. And it may shift how you're thinking about the situation, but at least you understand where the other person is. And so, in the loop of understanding, you take it in that way, and then you describe to the other person what you believe they've been trying to communicate to you. And that communication could be words, but also might be their nonverbals. And then check in with them to see if you got it. Um, and sometimes you do, hopefully. And other times you didn't, you got part of it, but not all of it. Sometimes maybe it's just not, you filtered it in some way that when it came out and you said what they thought, I was like, nope, that's not really it. Or it could be they heard what you said and actually was very similar to what they said. But then once they heard you saying it, they're like, well, that may be what I said, but not really what I think now that I hear you say it. And so it's helping them to feel heard and understood, which is such an important human craving that people understand me and get me. But also, you're really clarifying so that everybody's on the same page about what what they're saying, which could be something that's really important to them. Um, and I think you have to practice that skill. It's not so, it sounds, oh, yeah, that sounds pretty simple. It's not really so simple because of this distraction, the reactions you might be having, other information. And so building up the capacity to be fully present, to listen, and to show someone that you've listened and they feel heard and you actually have gotten what they said is such a critical skill. And again, not one that people necessarily learn in their professional education.
Right. Yeah, and I think, we all hear throughout your life how important it is to be a good listener,
Mm,
but you never get taught how to do that. You
exactly.
know? And
Exactly.
there's a real skill to it, you're right, and it is challenging to, um it's an easy concept, but
Mm,
difficult skill to master,
yeah.
and I just note for anybody that's listening who has kids, I've, um, practiced this with my kids, and when I can do it and remember to do it, it's amazing how much it changes the interaction.
Yeah. I was thinking when you were saying, you don't learn how to do it. I was thinking my kids who grew up with me doing
They've
that,
learned.
they learned how to do it. And one of my daughters actually works in a corporate setting and she uses it all the time. I mean, I think it's part of the way that she's successful at work is that she's able to do that. And people like that. I mean, when I've been looped, I'm like, oh, this is so refreshing.
Yeah,
That
yeah,
doesn't happen that much, and so being able to do it is really it's really a great important life skill.
yeah, it's really powerful. Well, this has been great. I wanna ask one more question, which is, kind of around the title of this podcast. So the title came from this quote from Justice Warren Berger, who said, "The obligation of our profession is to serve as healers of human conflict." And the first time I read that, it just kind of, knocked me over, and it's really stuck with me, and so um, I'd like to just get your just general reaction, whatever comes up for you when you hear the idea of lawyers as healers of human conflict. Like, what does that mean to you?
I mean, I think it's an amazing aspiration, and, um, to me, what it conveys is, as a healer, you're not just negotiating a deal and compromising positions. You're really finding the humanity in everybody that's in the conflict, as well as the other professionals that you're working with, because so many times professionals get into, um, they're part of the conflict. They become part of the conflict,
Yeah,
um,
right.
and so healing to me says we're looking at this as a bigger, complex situation that involves dynamics and emotions, as well as whatever the underlying content is. And if we could take that all into account and work through that together with sort of good faith and intent, um, that people will be more whole coming out of it, both the parties as well as the professionals. Because I think what's been for me a wonderful side benefit of using these practices is I don't I'm not so harmed by working with people in conflict and the negative hostile emotions that come up when you're in a big battle, um, that happens in difficult litigation. um, you can feel coming out of it as a professional, like I did good work, and even some part of whatever your history is might be healed a little bit by working through that. So there's a healing of the parties because they were able to work through this and come out with something that was good enough for the circumstances. There's some healing for the professionals because they did it in a way where the parties ended up in that place. And then that's also healing for the community that this conflict has now been worked through and it's not going to cause further harm, and that people learn how to work through it together. So that was a long-winded, but that came up for me when you're talking about healing.
Yeah, I love that. It's a really nice synopsis of all the aspects and elements. And two things that you said really stuck out. One is um, it's similar to client control and mediation outcome. One of the things that makes me cringe is lawyers' definition of wholeness and what it means to make someone whole.
Mm,
And I'm just noting that because we could do a whole episode on that. Um, and then this idea of um, the healing for the professionals that are doing the work. A big part of my story, and I'm sure a lot of lawyers that you've worked with in these trainings, is the burnout that happens in litigation and this kind of work. And when you're up to this type of work, that seems less likely to happen because you're doing things that are fulfilling and empowering and inspiring and all of these positive things rather than tearing things down.
mm, exactly.
Yeah. Well, thank you again. It's just a pleasure to talk to you, and I thank you so much for coming on. Is I want to give you some time, and I want to plug the Center for Understanding Conflict because I will just say it's an experience unlike any other, and I got to go to Green Gulch and be a part of that, and it's really unique and special. And you guys are doing amazing work. So maybe you could just let people know where they can find you and what trainings are coming up and anything else.
I'd be happy to. Thanks for asking me to do that.
Yeah.
Um, Yeah, so the center offers about, basic mediation and conflict resolution training several times a year. As you said, at Green Gulch is one place, which is in Marin County, but also in other locations. And then we do some other courses. One that we is another sort of frequent course is called Self Reflection for Conflict Professionals Intensive. So, this is how you learn to really pay attention to what's happening inside of you and how that benefits your clients and the way that you can use your own reactions and judgments and working through them to to help people work through conflict. Um, Another is we have one called Your Next Steps, which is a three-part series where people have gone through our training. They're like, oh, I'm so inspired, but now what? How can I incorporate that into my own work? So that's a course about that. We also offer webinars once a month on various topics, and people can join. We have a membership program called CUC Connect, and for an annual fee, you can come to the webinars live when they happen and also have access to our webinar library, which I think by now probably has, I don't know, 70 or 80 different webinars. Um, and I just think mine, and we have a monthly newsletter that people can sign up for. And um, we're in the fall, we're going to do something called Mediation Lab, which we did last year, which is people have taken the training and they're like, we've never had enough time to try things out or to see how it really works. So a mediation lab is more hands-on, a lot of practice. Obviously in the basic training, we have to have a lot of conceptual parts of it. In the mediation lab, we have brief refreshers, but then hands-on, we have demos of how to do something, then people try it out, and then more demos and more trying out. So it's really a way to get more grounded and how the model works and how you can work through mediations. And then we also have support and development groups where small groups of anywhere from 6 to 10 people, where you bring in your actual situations, your cases, your conflicts, where you're working as a professional. Sometimes people bring in their personal conflicts too. And we just talk through them and try and kind of do a deep exploration of what's going on to understand it. And then you go back and you're like, okay, I've got some things to try out on this. Uh,
Yeah.
there's probably more I'm forgetting, but that's a good chunk of them.
That's a lot of good stuff. I'll put the website in the notes for the
Yes,
episode so people.
it's very easy. Understandinginconflict.org.
Perfect. Great. And I referenced in an earlier episode, Gary Friedman, who's the founder of the organization, wrote a book called Inside Out, which was really helpful for me when I was questioning what was next and where I was going to go. And so I just referenced that again. But
He
thank you
also
again.
wrote another can I say one other
Yeah,
book, which is called
yeah,
Challenging Conflict. So the Challenging
right.
Conflict book is about our principles that we used and our model and examples of cases and going through the stages. So it's kind of the basics of our model. And the Inside Out is what I was talking about with the self reflection program. So that's the book that describes what we do and why it's important and how you do it.
Perfect. I appreciate that, putting those in context. That's all I have. I thank you again for taking the time to come and chat with me about this stuff, and thanks for all the work you've done for for these last few decades. I really appreciate it.
Well, thank you so much. And thanks for inviting me. It was my pleasure to be here.